Well, good evening, everybody. I'm Bruce Tammi, and this is my second program. We had one a week ago, and that was on decision-making if you need help in making your healthcare decisions. This program is going to be shifting over to the financial world. What happens if you need assistance or you would like help in making your financial decisions? And this can be a broad area that we're talking about as far as financial decisions. It can be anywhere from accessing your bank to paying your bills, to signing your tax returns, to signing contracts, things like that. And it's a little different from healthcare decisions. Typically for healthcare decisions, at least in Wisconsin, a healthcare power of attorney is triggered by your incapacity, your mental incapacity to make your own healthcare or healthcare-related decisions. It's a little different with financial powers of attorney because they have a broader use, and they're not necessarily triggered. They can be triggered by your incapacity to make financial decisions. But typically my advice is that you have them, when you put them in place, they're already effective. That is, they're not triggered by your inability to make decisions. Now, this program is going to be more or less like the other one about just advising you what you should be aware of and your options having to do with financial decisions. If you can't make them yourself, or you'd like assistance in making them. So that's what we're going to talk about today. Like healthcare decisions, in Wisconsin, if you can't make your own financial decisions and you don't have, you haven't appointed an agent under a power of attorney on a financial account or your financial accounts, or if you don't own accounts jointly, and I'll get into that too, how those work too, or if there's no guardianship in place. If none of those things apply to you and you can't make your own financial decisions, no one can for you. Not your spouse, not your parent, not your children. You end up going into court and having a guardianship or a guardian appointing for you. Talked about a little bit about that last week. And that's sort of a protective services situation, but it takes away a lot of your rights. And it's not necessarily that flexible. It's got protections and things like that, but you want to try to avoid it. So why is it important that you have someone appointed for you as a power of attorney or an agent to make financial decisions for you? Well, obviously, if you can't make them yourself, you can't pay your bills, you can't manage your finances, and from my experience, you also might be subject to financial abuse because, if you can't make your decisions, people can influence you, and perhaps, that's a fairly, it's not a huge problem, but it is a problem in Wisconsin and across the nation, financial abuse. So that's why it's important. Some of the situations that you have, you might ask the question, well, my spouse and I are listed as co-owners or joint tenants on everything we have. It can be your bank accounts, it can be your home, you own it jointly or as marital property. And the same for your financial accounts. Maybe your motor vehicles too are owned jointly. Is that enough? Well, the good news is that really helps. If you are on an account as a joint tenant, joint owner, you have, if the other joint owner or owners lose their capacity to make decisions, they can't access the account, the other joint owner can. Because under Wisconsin law, if you're a joint tenant of a bank account, either joint tenants have complete access to the accounts independent of each other. In fact, they own them So either one can, do whatever they want with the bank account, basically. Take the money out, pay bills, do things like that. So that helps a lot. But for other sorts of joint accounts or joint ownership of property, your real estate, even motor vehicles, a lot of financial accounts, investment accounts, you require two signatures. That is, if they're two joint tenants, both have to sign, both have to make these decisions. So for those things, if one person, one joint tenant loses the ability to make decisions or can't, even sign their name or do something like that on a financial a piece of jointly held property, you're stuck. You can't do anything. So for example, if you wanted to sell your home and say your spouse got to the point where they can't even sign their name, they can't make financial decisions, even though you're the joint tenant, you can't sell it. You can't mortgage it because it requires two signatures. So that's why it's important that you have, for example, an agent in place. For spouses, you typically appoint each other as your financial agent. And then, normally it's recommended that you appoint alternatives too. So yeah, it's helpful to have joint property, especially for spouses. But it's not a complete fix, so you need something more from that. Another question that I've gotten in my career as a lawyer is, well, I've added my child, just say with child, to my bank account. Is that enough? Well, it might be. If you just want the child to get access to a particular account, that might be good enough. But the question I ask then is, what do you mean by adding the child to the account? Again, I sort of talked about this. You can add someone to your account as your agent, power of attorney agent, or you can add them as a joint tenant of the account. Now, if you've listed your child as a joint owner, the child basically has complete access to the account, just like you would. You've actually given that child ownership of the account along with you. So yes, they have complete access. And if you added somebody as your agent, power of attorney, to that account, they can get access to the account, but it's not an ownership interest. So they can use the account for your benefit, or as you tell them to use it for you. So so for example, if you just want someone to, if it can even be for convenience, to help you or pay bills, do things like that, you can add them on a financial account as power of attorney. And almost all banks and financial institutions have their own way of doing that. I'll get to having a general power of attorney in a minute. But banks and financial institutions, if you say I'd like to add my friend, my child, my spouse as a power of attorney agent, they'll have their own form that you complete. And usually it requires the signature of the person you're appointing too, because they want to have that on file. So you can do that. So for individual accounts, you can do that. And that goes to not only bank accounts, but investment accounts, with financial services companies, things like that. So that's sort of an easy way of doing it. You don't need a lawyer to do that. You can add them. Where doesn't that help you? Well, getting back to that real estate situation, if a joint tenant, if a property is held in joint tenancy by two people, if one can't act at all, there's no way you can appoint a power of attorney on a piece of real estate separate from having a general power of attorney. So you need something more than just doing that. And even something as simple as a motor vehicle. Typically, if you sell your motor vehicle, if there are two people on the title, both have to sign. So so even for stuff like that. And so that's where a general durable financial power of attorney comes into place, to cover a broad area of your financial needs. I talked a little bit about how you do add an agent to a financial account. And I said that, that typically do that right through the bank or, investment company, financial services company. The one thing I found, and the next thing I'm going to talk about is how you cover these other general circumstances, even paying your bills or signing your tax returns or things. That's where a general durable financial power of attorney comes in. That's where you actually appoint one or more persons to do these financial transactions for you. And it can be broad in scope, where they can basically do anything that you need financially for you, or it can be very limited. These financial powers of attorney are even used for one-time transactions. I've had numerous occasions when I was practicing law where, for example, somebody lived out of the country, out of the state, and was buying a home or selling a home, and they needed somebody here to sign all of the paperwork for them. So you can limit a financial power of attorney to a one-time transaction, selling your home, buying your home, or anything else like that. So that's another use for it. Not as common as a general durable financial power of attorney, which basically gives much broader authority. And why would you need broad authority? Well, sometimes, especially later in life, you get in complex situations where property might have to be transferred, maybe even gifted, things like that. I'm not saying that's the norm, but those situations do come up. So financial power of attorney, if it's tailored right, can cover all of the circumstances that you might need it for in the future. And some of those might be undetermined at the point. The question you might raise is, well, can I do a general financial power of attorney myself? Wisconsin does have a uniform form, sort of like it has a uniform form for healthcare powers of attorney, but it's a little different. From my standpoint, I didn't use that form in my practice. My financial powers of attorney didn't look like the state form. It's something where you can, check the boxes of certain things you allow your agent to do, but it's much more limited. And the other thing that I worried about a lot is, I talked a little bit about financial abuse, especially if somebody becomes unable to make their own decisions or doesn't do it clearly. Forms like that are subject to abuse much more than if you have an attorney do it, because of course the attorney's looking after you, they're not looking after themselves. So if somebody comes, it's such an important thing. You're talking about everything you've probably accumulated in your life, I said later that probably the most important thing that you do in coming up with who's going to be your agent is, it's probably determined who do you trust to make these situations. Whenever you give a financial power of attorney to someone, you really should absolutely trust them from the standpoint of making competent but also fair decisions. You don't want anybody stealing from you or misusing the power of attorney or in any way. So it's a really important thing because if you give financial power of attorney to the wrong person, under Wisconsin law, I talk about that a little bit later, but in that the handout I've given you, But under Wisconsin law, if you give somebody a financial power of attorney, they typically can't use that for their own benefit, okay? That's what the law says, unless you put it in the power of attorney. Some powers of attorney, and for particular reasons, a person wants the agent to be able to gift property, maybe to themselves and other children and stuff under certain circumstances. That's different, but if it's the general power, financial power of attorney, the agent can't, for example, take your property, gift property, your property to themselves. That's against the law, basically. But, you know, it might be too late if you give the wrong person a financial power of attorney, because they've already done that. You know, then it's going after the fact. So that's why it's probably the primary, you know, importance, at least from my standpoint, in giving a financial power of attorney is the trust you have in the individual. So you should trust them completely, or at least completely, for what you're authorizing them to do. And again, general financial power of attorney can be very broad in context, or it can be more limited. Let me see. What are the steps in appointing a financial power of attorney agent? The first one is to decide, what do you need that for? What's the scope of authority you want to give the individual? Do you want to give them broad authority to help you out with financial decisions? And one thing I want to also point out is that a lot of financial powers of attorney are used for convenience. So for example, I've had numerous clients over the years who wanted their child or someone else to help them out because they had limited mobility, they couldn't get to the bank. They could still make their own decisions, but they wanted somebody to help them with things. So that's another reason why you want a financial power of attorney in place. It's unlike a healthcare power of attorney where it's triggered by your inability to make your own healthcare decisions. So almost, I'd say 95% of the financial, general, durable powers of attorney I did during my career were broad in scope, but they were tailored to the person's situation. So, you know, as far as the authority you want to give, again, it can be very limited to a single bank account, or it can, you know, cover all of your finances, or anywhere in between. And that's where actually getting advice from an attorney through the process of this can be very valuable, because rather than just, you know, doing a shotgun towards your needs, you know, and you as a person not in the field of law might not know the consequences of giving certain authority or not giving certain authority. Part of the thing is that I thought my job was as an attorney and doing these sort of documents was to educate people and then fit everything to what the client may need, both now and the future. So that's usually I'm not I'm not in the business anymore, so I'm not selling anything. So, but that would be my advice. Okay, so the next thing you want to do is to talk to your, you know, the person you'd like to be your financial agent under a power of attorney. You want to make sure that they're comfortable in doing that sort of job, they're available to do it, and you also want to make sure that they know what you would like. You know, just, you know, and they also have to know basically where you have your finances, or where they can, if for example it's something that might come up in the future, where you keep your stuff and things like that. So you want to talk to the agent, make sure that the person's willing to serve as your agent too. Yes.
The question, you keep pointing out the fact that compared to last week, this time, most of them, these arrangements are not triggered by anything, right? So that means they're good as soon as you sign them, correct?
Yeah, and in fact...
So how do you balance that with, I don't have any intention of needing this for a long time, but after I need it, it's probably too late to sign paperwork, right?
Correct. Correct.
So are there words or things you put in it to trigger various times, or is it all just one?
No, typically I'm going to get back to the trust.
Okay.
The trust and your agent knowing what you want and discussing it with your agent. So again, if you don't trust the person 100%, I advise you not to give that person a financial power of attorney. And so if you trust the person, you'll trust them to do the right thing now and later. The thing is, if you trigger your financial power of attorney by incapacity, the difficulty with that is, say you've got banks here and there, and maybe investment accounts, and you've got things spread around. You might have real estate and motor vehicles, or who knows what else you might have. If you have all of this stuff and your power of attorney says, let's just use sort of a basic thing like it would be on the healthcare power of attorney. If I become incapacitated and can't make my own financial decisions, I appoint Andrew Holmes as my financial agent to make decisions for me. Okay, what that would require typically, because financial services companies, banks and the like, they're careful. They don't want to get in trouble. They don't want to have somebody take out money from one of their clients' accounts and stuff like that. So they're very careful. So if you have that sort of trigger, every single bank, you're going to have to convince them, if you're the agent, that so-and-so is incapacitated. Which makes it very difficult to operate. And in fact, you were talking about giving a general power of attorney. Even if you have the best general financial power of attorney in the world done, and I thought I did a pretty good one when I did them, but even under those circumstances, many financial services companies are hesitant to take them. Even in Wisconsin law basically says this: if you've got a valid financial power of attorney and it hasn't been revoked, and you have no you have no knowledge, or there's no evidence that there's been some sort of illegal thing going on here, you don't have any of that. In Wisconsin, the bank's required to take documents and honor them. Do banks always do that? No, from my circumstances. That's why, they have their own forms and things like that to appoint somebody an agent. So usually the best thing to do is, even if you have a general power of attorney covering everything, it's good to get your name on, contact your financial services company, your bank, or whatever investment firm, and make sure if they have a form or something, have that filled out too. That way there's no problem. You would think that if you have a valid financial power of attorney, and in Wisconsin, a photocopy or a digital copy of an executed original is supposedly, under laws, as good as the original, is valid and stuff. But I mean, I don't know how many times in my career banks have said no, or especially big financial companies, big ones that are throughout the country, and state laws vary and stuff like that. They'll say, no, this form, we won't take a copy of it. We want a signed original. And sometimes they don't even take the signed original. They'll say, no, you got to do our own form or something like that. So, yes.
Do you advise us to do that for everything that's financial, say like houses, cars, and things that are not listed in the will?
A power of attorney is only good while you're alive, okay? It has nothing to do with what happens after you pass away, okay?
So for everything that matters though, other than banks, should we get that introduction made?
You should have a general, durable power of attorney. What does durable mean? That's a power of attorney that is valid if you become incapacitated.
So like if we have, but you're saying a lot of times it's not respected. And that's why I say that in the bank, you get a form that they respect and recognize. Where, in addition to banks, do you advise you use?
There are, if it's not a financial services company, again, they're not going to have, there's not going to be a mechanism to appoint somebody. So for example, you were talking about cars or real estate. You can't, there's no other way other than to have this general power of attorney in place, to have somebody to be able to help you or make decisions or, on financial property, so.
So if the mortgage isn't at the same bank as the investments and the savings, so we would also approach the bank who holds the mortgage and make that introduction of who our power of attorney is in that will.
If, for real estate, typically, yeah, you'd, if, for example, I don't, if the company where you have all your, your mortgage and your bank accounts or your financial accounts, it's all one company, probably just getting it set up once there is the thing. But a lot of people have many different, banks or financial services companies or things. So, so my advice is typically having this general, durable financial power of attorney, again, with whatever authority you want to give. From my standpoint, usually if you're going to give this, it should be broad authority so it can cover everything that's needed in the future, because again, you're not going to give it to somebody you don't trust to do the right thing about it. So, but what I'm saying is, if you have, even if you have this, typically what I advise my clients to do is, once we get this financial power of attorney, said, take a copy to your bank, and then they will have that as of record. And then if they want you to sign some other form or something else, they'll tell you. There have been banks and financial services companies that have just taken the general durable power of attorney and added people on. There's some, but again, there's quite a few that don't do it that way. Especially, and there's some reason for that too, because a lot of these financial services companies are nationwide, maybe international too. They're all over the place, and state laws do vary. And so I've run into numerous circumstances where, again, they're questioning the financial power of attorney I did for a client. And it's just because it's in the central office where they're looking after 50 states, and the laws vary and stuff. They take the cautious approach and say, well, from our standpoint, this doesn't make it for us, even though Wisconsin law says you got to take it, So I know this sounds a little complex, but all these things I've talked about, I've faced in my legal career. I've had, so it's best to get this all in place in advance Again, if you have a general power of attorney, take it to your bank, financial services company. Again, if they want something different, if they have their own form, it's usually not a big deal. They send you something or email it to you to sign, you know, and maybe have your agent sign. So, but that's a good idea. Another question is, you know, if I give a financial power of attorney to somebody, does that take away my rights to make decisions on accounts or whatever I've given authority for? Does that sort of like, am I giving away my rights? And the answer is no, not at all. Actually, in Wisconsin, an agent is supposed to act for you, is supposed to use your property for your benefit. And also, even though, a lot of people are thinking of the situation where, they can't make decisions anymore. In the use of the power of attorney, and in a lot of instances, that's exactly what it's used for. But again, aside from that, the powers of attorney can be used for many different things, and I think I mentioned that earlier. But for example, one of the other uses of things like financial powers of attorney are for these sort of things, just to, for example, to facilitate something where one person isn't available, or it's more convenient just for the other to act for both of them. I think I mentioned something about selling real estate, but it can be for any sort of uses, just a multitude of uses practically too. So if you're a husband and wife or whatever, if you're agent for one another, rather than both of you having to sign, for example, particular papers, maybe one of you can if the other isn't available. So it can be used for convenience a lot of times. So let's see, where am I at? Yes. Then it's, of course, that's, unless you have an alternative. So it's usually best to, some circumstances, clients or people only want one person, trust one person, that's fine. But if you have more than one person you would trust in making your financial decisions, it's usually best to name more than one. And this can even be, for sort of simple situations. Maybe your other agent isn't available. They're out of the country, or they're there, they can't be contacted, then you have the other. Or it can be the other agent loses can't make decisions too. So if you have your power of attorney set up that way, you don't have to change anything. On the other instance, if you've appointed one agent and you don't want that agent anymore, you just revoke the other power of attorney and you get a new one in place if you want another agent. So, and you can do that at any time. So if, for example, you gave me a financial power of attorney, and you decided somewhere in the future, I don't want Bruce to have this anymore. What you have to do is you have to tell me that. The best thing, of course, is in writing. So in case I decide, I didn't hear you say that. But yes, that revokes. You can revoke a power of attorney at any time. So if, it can be if you say, I don't want so-and-so to make, be my financial agent anymore, it can be, you can withdraw that at any time, so cancel it out. So, again, number 8, you're not taking away any financial rights. Number 9, I have the same link there. And again, if you go to my website, brucetammi.com, and at the top it has a homepage, contact, and docs. If you click on docs, I have all of the papers that I've given you today, and the other one, and a few other things there. And actually, if you pull up either of this week's presentation or last week's, it has a direct link. So under that, where it's in blue, Advanced Directives, if you just click on it, it'll take you to the website. If not, it's the State of Wisconsin website, Department of Health Services. So you can even Google that, and you could get to that. So if you want to look at the financial, this statutory uniform financial power of attorney, it is there along with the statutory health care power of attorney. So you can take a look at that if you want. Again, once you get your powers of attorney in place, make sure to discuss all of this with all your family. Occasionally, you want to make sure that, for example, if you have just a typical situation is you have multiple children and you're only giving a financial power of attorney to one or two or whatever, you want the others to know that this is what you're doing. It's no hard feelings or whatever, but just so that, people, occasionally if somebody's left out and then they find out their sibling or somebody else has been appointed financial power of attorney, they think there's something going on here because I didn't know about this. So I found that if you tell everybody that's involved with this, your children or your family, other family or whatever, this is what you want. And, it's nothing, sometimes it's a little difficult to do that, but I found that then that does away with any sort of conflict. So, because they already know this is what you wanted. You wanted so-and-so to be your financial agent. In many instances where families get along, it's not a problem anyway. So, but, I've run into numerous family situations where there is conflict, between siblings and things like that. So it's good that you make sure everybody knows what you've decided. The last thing I have here is that you might consider a trust. If you have a lot of property, especially if you have property in and out of, in more than one state. For example, I've had a bunch of clients, and I don't know if any of you, they have property in Arizona or Florida or both or California or whatever. It's a lot easier if you consolidate things, your property into a trust. And I'm going to get next week, I'm going to get into what that is actually. But I'll say a few words about it. A trust is basically a separate entity. It's like, you've heard of corporations and things like that. It's not a corporation, but it's something separate that holds your property. And the type we're usually talking about is you're creating it yourself. There's a trust agreement. That's what sets it up. And it's got all sorts of terms and, all sorts of things to it. But basically, it's this entity that you put your property in. Typically, you are the initial trustee. Not always, because sometimes you want somebody else to help you with that. But you're the trustee, so you control everything in the trust. As far as being the trustee, you can buy and sell property or do whatever you want, put things in, take things out of the trust. But it's a separate entity that goes on if something happens to you. So if something happens to you, say you lose your ability to make decisions, you're typically appointing a successor trustee or trustees, and that person can step in immediately and has this authority over your property to basically manage it for your benefit. And another advantage to it is that if you pass away, the trust is still there. That means it's still holding your property, and it's got all of the terms in there. It basically takes the place of a will, because the typical trust, you're describing what happens to your property if you pass away, where it goes, just like you would with a will. But the thing is, there's no need for any probate or anything else, because this trust entity is there. It doesn't go away when you pass away. It only goes away when the trust agreement says it goes away. Typically, it's after, if you pass away and all your property is distributed, then it ends, typically. So that's one thing, and again, I'll get into more details on things like that. So that's another way, and see what it does too is, because if you become, typically the trust agreements will have in it, if the trustee becomes incapacitated, then the successor trustee takes over. So it sort of takes, it makes sure that, it's actually even a little easier and more protection than a power of attorney, because again, the trustee steps into your place, and you had been trustee controlling all of your property. Now the successor comes in and does it. And it doesn't require going to all the banks and stuff like, if you've already listed, for example, on your accounts that you're successor trustee, but it doesn't require all of this going around and changing things. So that can be an advantage too. So those are some of the basics and financial decision making. Again, from my standpoint, trust in your agent is the most important thing in getting together a financial power of attorney. Again, generally, it's good to have broad authority. The typical thing that you would not include in a power of attorney, a general one, unless you need it for some particular reason, is gifting authority, things like that. So you wouldn't necessarily give your agent the authority to gift your property away. Unless it's part of a plan, part of needed planning in the future or something like that. So that's sort of the basics. Are there any questions about? Okay, next week I'll talk a little bit about basic estate planning, going over what happens when you pass away. And again, it's geared towards Wisconsin, basically Wisconsin law and stuff like that. So that's it. Thank you for coming.